Former President Donald Trump appeared in court in Miami on Tuesday, where his attorney pleaded not guilty on his behalf to historic federal charges, bringing the Espionage Act into sharp focus as a key law implicated in his handling of government secrets while out of office. The vast majority of the charges against him were brought under Section 793E of the Espionage Act for his alleged willful retention of national defense information. The century-old law specifies the types of information that, if in the wrong hands, could be used to harm the United States. Prosecutors claimed in Trump's indictment that he took approximately 300 classified documents with him when he left the White House and then repeatedly tried to avoid handing them over, despite requests, a subpoena, and, eventually, an FBI search. Trump and his attorneys have both denied any wrongdoing. They argue that because he had every right as president to keep the documents under the Presidential Records Act, the Espionage Act does not apply, an argument legal experts refuted in interviews with ABC News. The former president and his supporters have claimed that he is the victim of a legal double standard, citing classified documents improperly held by his own vice president and current Republican political rival, Mike Pence, as well as his own past and present. While those comparisons may be politically useful, the facts in each of those cases show that they do not come close to what Trump has been charged with. In Pence's case, it is believed that a dozen classified documents were discovered in his personal possession after he left office and turned over to the Department of Justice. The DOJ investigated and decided not to charge him. Prosecutors also declined to press charges against Clinton for handling classified information through a private email server she controversially set up to conduct government business while serving as Secretary of State. According to federal authorities, approximately 193 emails containing classified information were sent to her from Clinton's personal email. Prosecutors and agents could not prove that Clinton had actual knowledge that the emails in question were classified, or that Clinton used the private email account with the purpose or intent of receiving classified information on them, according to an Inspector General investigation of the Clinton investigation. In other words, prosecutors were unable to establish that Clinton willfully disobeyed the law. Meanwhile, Special Counsel Robert Hur is conducting an investigation into classified information discovered at a non-government office previously used by Biden and at his home. Biden has stated that he will fully cooperate with the investigation. The precise number of classified documents discovered at Biden's former office and home while he was out of office is unknown. He and his aides have repeatedly stated that it was a small number and that they were returned when discovered. When considering the stakes at stake, comparisons to actual cases charged under Section 793E may be more instructive. Retired Air Force Lieutenant Colonel Robert Burcham was sentenced to 3 years in prison earlier this month after pleading guilty to a 793E violation, though that was less than half of the 78 months sought by prosecutors. Burcham illegally kept top-secret National Security Agency documents on a thumb drive at his home in Tampa, Florida, according to court records. Prosecutors said his motivation for illegally retaining the documents was unknown, but investigators discovered more than 300 classified documents at his home, a storage container parked in his driveway, and his overseas quarters. According to court records, Burcham was never found to have given classified documents to anyone. According to court filings, the average prison sentence for cases involving top-secret information similar to Burcham's is more than 4 years. According to the indictment, Trump also kept top-secret documents with him at his Mar-a-Lago estate. Harold Martin, an NSA contractor, allegedly kept vast amounts of classified information strewn about his Maryland home, shed, and even his car. After pleading guilty to willful retention of 20 classified documents, he was sentenced to 9 years in prison. Reality Winner, another former NSA contractor, was sentenced to more than 5 years in prison in 2018 after pleading guilty to a Section 793E violation for sending a classified U.S. intelligence report about Russian interference in the 2016 election to a journalist. Trump, on the other hand, has not been charged with disseminating classified information. Trump, almost certainly unaware that he would be charged under the same statute one day, complained on Twitter at the time that Winner's sentence was for small potatoes and that Clinton's behavior was worse. According to former Justice Department official and George Washington University Law School professor Stephen Saltzberg, the United States has a history of carefully prosecuting Espionage Act cases. We do not get many Espionage Act cases, Saltzberg explained. And when we do get cases, it is usually due to outrageous behavior. It is probably as clear a statement of charges I have ever seen, he said of Trump's indictment.